So we're going to talk about three things broadly. Firstly, choosing a structure, many ways to structure our communities. And the way somebody put it once, I was on a panel with her. She runs a land trust in Toronto, and she said, look, our relationships exist. They're the reality. The underlying relationships are the reality. We need to find ways to communicate to the government this reality. And very often that's what the work is of, articulating things in bylaws, articulating things in a formal constitution, our purposes, whatever. But the primary thing is always your relationships. So first we're going to talk about the structure, how to give some structure to those relationships. Secondly, we're going to talk about the actual process, the nuts and bolts of incorporating. And then thirdly, we're going to talk about the process of applying for charitable status and some broad detail about who qualifies and so on. After each of these sections, and we've got a small enough group that honestly, if you want to ask a question at any point, feel free to ask it. You have 2 hours. But after each of these sections, I'm going to pause for questions. First, a little bit about me. My name is Benjamin Miller. I'm a staff lawyer with Community Legal Education Ontario, CLEO for short. CLEO is a legal aid clinic, part of Ontario's legal aid system. In contrast to other legal aid clinics, we do not provide legal advice or representation. So I cannot review your bylaws, I cannot give you specific legal advice about whether or not you qualify, nothing like that. But what we do is provide general legal information and education like this session that I hope you'll find practical, plain language, and accurate. Now, the nonprofit law part of CLEO is a small part of CLEO. We've got resources on immigration and refugee law, on social security, on family law, criminal law, you name it. If you, your workers, your clients are asking you questions about these areas, we have free legal information online on stepstojustice.ca. We also deliver trainings to frontline workers who want to understand better how to connect their community with the legal information they need. So if you're getting these questions and you don't know what to do with them, go to our website, stepstojustice.ca, and you can reach out to me and I can connect you with one of my colleagues who organizes trainings for frontline workers. Now, this session is funded by the Law Foundation of Ontario, so I would be remiss if I did not mention that, and it's delivered in partnership with the Ontario Nonprofit Network. Already mentioned, feel free to ask questions throughout. This session is the product of many, many questions before. Every question makes this presentation better. Okay, a few disclaimers. For those who were here for the first session, I'm fond of disclaimers. Disclaimer number 1, this presentation is general legal information. It's not legal advice particular to your situation. Point number 2, this session isn't meant to be introductory. It's not meant to be comprehensive. We have more information online on our website, nonprofitlaw.cleo.on.ca. I'm sure you'll get that link after the session in an email following the session. Thirdly, this session is about law. It's not about everything else. A lot goes into organizing community. A lot goes into running a nonprofit. Business savvy, politics, culture, history, psychology, relationships, all kinds of things. The law is a small part of what makes a nonprofit work. And just because somebody knows the law doesn't mean they are an expert in all those other areas. The truth is, you almost certainly know better what is right for your community as far as its culture goes, as far as its values goes, as far as its mission goes, than I do. So what I'm providing is legal information that may be relevant to you as you think about what the right answer is, but I am sure that you know better than I do what the best answer is at the end of the day. And then finally, today is about law. It's not about your funders' expectations. One of the things we may come back to a few times over the course of tonight is that one key determining factor of what structure you choose is how you're going to sustain yourself financially. An organization that is looking to fundraise from small donors, charitable status is going to be far more relevant to them than someone who, for example, is generating income through fees for service or membership fees, where it's not receivable anyway, potentially. So maybe charitable status isn't right for them. Similarly, if the specific funders you are interested in getting support from require incorporation, then it may make sense to incorporate. If they require charitable status, and there have been some changes in the law in this area recently, then it may be more or less relevant for you to have charitable status. So really thinking about the business case for all of these decisions is an important piece of this, but we're just talking about the law, the legal aspects, the nuts and bolts. The business realities is something you'll understand better. Okay, so we're going to begin with choosing a structure. We're going to talk about the pros and cons of incorporating. We're going to talk about the different ways you can incorporate. You could incorporate it as a business, you could incorporate it as a nonprofit, you could incorporate, we're going to understand the difference between a nonprofit and a registered charity. Different membership models. Membership is probably the most crucial decision in your governance structure. And then finally, we're going to talk about a bit about shared platforms. If you haven't heard that term before, don't worry, I'll explain what that means. Okay, so pros and cons of incorporation. So as I've already mentioned, you do not need to incorporate. There's no general rule that says all nonprofits need to incorporate. If you are not incorporated, from a legal point of view, you're likely what's called an unincorporated association. The rules that apply to an unincorporated association are not written down in any statute. There's no law or legislation that tells you what the rules are for an unincorporated association. The rules come from court cases that have accumulated over centuries of the common law. To learn more about the rules of unincorporated associations, you can go to our website, nonprofitlaw.cleo.on.ca, and you'll find a page dedicated to unincorporated associations, which will give you some of the basic rules. We're skipping ahead to incorporation, but you may not want to, and then wonder, well, what are the rules that apply in the meantime? Okay, so what are the pros and cons of incorporating? So some of the pros include protection from liability. If you haven't heard anything else about incorporation, you've probably heard this one. When you create a corporation, what you are creating is an artificial person. It's kind of like you're building a robot, right? A legal robot. Sounds much cooler that way, right? So you create an artificial person, and then that person is liable for what you do as a group. Not you individually, the person, the corporation is liable. Now, that doesn't mean you can commit a bunch of crimes and hurt a bunch of people and get off scot-free. You're still liable for your personal actions. But just because the group does something that may result in harm to somebody doesn't mean you're personally going to be on the hook for what the group did if that group has its own legal existence. If you are unincorporated, there are just people. You're just a group of individuals. There is no, technically the group as a whole doesn't exist separately. It's just you. So whatever happens, you are essentially on the hook, firstly individually for your own actions, but you may be on the hook for the group's actions, depending on what the rules of the group are about sharing liability. So the first benefit of incorporating is protection from liability. This is going to be more relevant to those organizations that are engaged in different kinds of risky activities. So for example, if you're playing bridge, let's say, I mean, I don't play much bridge, so I don't know, maybe it gets heated sometimes. Maybe there's some throwdowns and there are risks I don't know about. But if you're playing bridge, chances are the practical risks are a lot less than, for example, if you're dragon boating, let's say, or archery, or rifle club, or you name it, right? So think about what are the practical risks? What might the liability be? Do we want to be protected from them? A second pro is a permanent legal existence. What I would actually add to this is this idea of formal structures help in times of isolation. It gives you something to come back to. It gives you a framework to work with. So when you have an unincorporated association, you just have the people. If the people leave, poof, it's gone. But with a corporation, even if the people leave, the corporation continues to exist. It's kind of a zombie corporation. And there may be advantages to having a structure that doesn't depend on the presence of any in particular individual. That may be more sustainable in the long term. It gives you a clear legal framework. So when you're an unincorporated association, I mentioned your rules are basically written in court cases, and you have to go figure those out. There isn't much written online, unfortunately. But unincorporated associations have basically total flexibility to decide what their rules are. What that means, however, is that you have to actually go through the effort of coming up with all your rules. When you're a corporation, you're governed by the statute. So the statute, the law, gives you a whole bunch of rules to start with. Now, as I'll mention in a moment, that can be a pro and a con, because you may not want all those rules. But if you're somebody who doesn't want to start from scratch, you like this idea of having a pre-existing framework that you don't have to think about all these individual things, then incorporating gives you that pre-existing framework. And then finally, eligibility for funding. So some funders only grant to incorporated groups. I think the reason for this mainly has to do with their perception that if a corporation can't just get up and leave, so if there was ever a legal problem, they know who to sue, right? So from their perspective, it's less risky to grant to a corporation. But the truth is, lots of shenanigans happen with corporations. So I don't know how true to life those expectations that it's lower risk actually are. But anyway, I think that's the psychology behind a lot of funders only granting to corporations. Especially recently, the rules have changed where even charitable foundations can, in fact, grant to unincorporated groups under certain circumstances. But many funders choose not. Cons, more paperwork. So you have to apply, then you have to maintain the corporation. And applying and then not maintaining it is just you're asking for a headache. You're asking for, down the road, if there's ever any issue, you're going to have to clean up all that paperwork, and it's much more complicated if you are a corporation often. There's a cost to it. So the cost to becoming incorporated is a few $100s, depending if you're incorporating provincially or federally. It's cheaper federally. But there's a cost, and then if you want to get legal advice or other kinds of advice, consultants and so on, then that would be an additional cost, which would depend if you're getting it for free or you're getting it at a reduced cost, whatever. But the cost can very much vary. And then finally, it's a more rigid framework. Unincorporated associations have all the freedom in the world, basically, to come up with whatever rules they want. Corporations have to follow the corporate statute. So if you find that to be problematic, to be difficult to follow and so on, maybe incorporating isn't right for you. But let's say you've decided to incorporate. What are your options in terms of how to incorporate? So there are, broadly speaking, two options. It could be a for-profit organization or a non-profit organization. What are the differences? So businesses can pursue any purposes they want. You could have a business who works on fundraising for heart disease. You could have a business that works on settlement services. You could have a business that organizes social events, what have you. That's fine, they can do that. The difference is that with a business, you have shareholders. There are people who own the business. It's an asset of theirs. Whereas with a nonprofit, you don't have shareholders, you have members. The members of a nonprofit don't own it. They oversee it, they govern it. It's, the organization is accountable to them. Now, particularly if there are a lot of economic interests involved, as is sometimes the case with, let's say, golf clubs, for example, people want to have some share in it. They want to have some asset, and so businesses may be more appropriate to protect their economic interests, although there are ways of doing it even with a nonprofit. But it's harder. With a nonprofit, it reflects the values that nobody owns the community. It's a community for all. At the end of the day, there isn't an expectation that somebody's going to walk away with the assets. The assets are being used for public purposes. Secondly, the legal responsibilities of directors are a bit different in businesses versus nonprofits. In businesses, the directors have a legal obligation to pursue the best interests of the corporation. And very often the best interest of a business corporation is maximizing profit. Not always. There are some court cases that explain when businesses have to take account of other kind of considerations. But broadly speaking, directors could be sued for failing to do the profitable thing. In a nonprofit, it doesn't work like that at all. The obligation of the directors is, again, to pursue the best interests of the corporation. But the way the interests of the corporation are thought about is totally different. The interests of the corporation are bound up in the purposes of the group, the stakeholders of the group, the community, the surrounding community, etc. The directors are held to account for pursuing that mission rather than for pursuing profit. And then finally, businesses and nonprofits aren't eligible for the same kinds of funding. Sometimes businesses are eligible for funding and for loans that nonprofits aren't. Sometimes nonprofits are eligible for funding and for loans that businesses aren't. So again, as I mentioned before, think about where are you planning to find funding? How do you sustain yourself economically? That will be a major determinant often about whether you decide to incorporate as a for-profit or as a nonprofit. Now, thinking about what makes nonprofits different. So I mentioned already, they have members rather than owners. Secondly, they are tax exempt. Now, sometimes I say this to people and you can see the dollar signs in their eyes. They light up, oh, tax exempt. Well, hold on. The reason they're tax exempt is because they're limited in what kind of funds they can raise and what they can use those funds for. So registered charities, and we're going to talk about that in a few, next slide. Registered charities actually have lots of flexibility when it comes to raising revenue, and in theory can raise an unlimited amount of revenue. There are charities in Canada with $20 billion in assets. There's one in particular, it's not charities, there's one. But in theory, you could have charities with lots and lots and lots of assets. Nonprofits, it's a bit different, and I've written about this for the Ontario Nonprofit Network. So if you go to the Ontario Nonprofit Network blog and you look at recent posts, you'll see a few from me about reserves. And the interesting thing is this applies whether or not you incorporate. CRA doesn't care if you're incorporated or not. They want to know, are you operating like a business or not? And what they look at to determine if you're operating like a business or not is, are you operating with the expectation, and you're planning to earn a surplus year over year, or are you operating on a break-even basis? It's not enough just to say, sure, we're earning a surplus year over year, but one day we're going to put it back into purposes. You can't be that vague. If you are, you can earn surpluses. That's part of being a financially viable organization. So anyone who's told you you're not allowed to earn surpluses if you're a nonprofit, that's a myth. You can earn surpluses. You can even earn large surpluses year over year. But you need to be able to justify those surpluses in what's called a reserves policy. The reserves policy needs to be able to explain to the CRA, if an auditor ever looks at it, why you are accumulating this money, why this amount of money, what are you planning to do with it, how does that relate to your purposes. So for example, you could have a reserves policy that says we're trying to buy a building. Great, okay, buildings are expensive. So you need a great big reserve. So fine, so every year you're earning surpluses in all your operations, and that's fine. You could earn surplus year over year, but you're you're earning the surpluses for a purpose, and that purpose is nonprofit in nature. Now this isn't the only factor, and you can read more about this online. The CRA has published its views in various places. It looks at the big picture, basically, and it does a kind of holistic assessment. What is the driving purpose of your organization? Is this really, you're calling it a nonprofit just to be tax exempt, but really it's a business? Or are you a business that just happens to be doing well financially? And so there are various factors. Businesses, they pay tax, right? But it's a much more straightforward determination. Nonprofits, you don't pay tax, but you need to operate within what the CRA considers to be a nonprofit. Okay, so whether you incorporate or not has to do with your corporate status. It's governed by the corporate legislation. There are two, in Ontario, the two most common statutes that nonprofits incorporate under are the Ontario Not-for-Profit Corporations Act and the Canada Not-for-Profit Corporations Act. There are others, those are just two examples, but they're the most common. That's called corporate law. Whether or not you are a charity is a function of tax law, so your status under the Income Tax Act, as well as provincial trust law. So being a charity in Ontario, you're governed by the Trustees Act and the Charities Accounting Act. If you're a registered charity, meaning you applied to the Canada Revenue Agency and you were accepted, you can do things like issue tax receipts and so on, then the rules that apply to you as a registered charity, you're going to find those on the CRA website and in the Income Tax Act. So these are different areas of law. They both apply to any given organization, depending on whether they're a nonprofit and or a charity. So what's the difference? What are you getting yourself into when you take on the added status of being a registered charity? So a charity is a nonprofit whose purposes and activities fall exclusively within one of the following 4 categories. Remember, it needs to be exclusive. It's not enough to just do some things that are charitable and some things that aren't. You have to exclusively operate in these 4 categories, at least one of them. Number 1, relief of poverty. Now, one thing I'll note about relief of poverty, and this really tells you about how old charity law is. Charity law dates back to 1601, Statute of Uses of Queen Elizabeth. And relief of poverty is charitable. Prevention of poverty isn't. You might say, well, what? I mean, if relief of poverty is charitable, certainly prevention of poverty should be. No, the person has to be poor first for you to help them. Yeah, so that matters, for example, if you're in an organization that wants to get ahead of the game and wants to prevent people from being poor, right? You want to build their assets, let's say. You want to help them with a business or something. They're not poor now, but they're at risk, right? So maybe you'll fit under other heads, what they're called heads of charity, other categories of charity. But relief of poverty is only where the people you are helping are already poor, however you define that. There are different ways you may define that. The second category is advancement of education. So many people are surprised to find out that most universities in Canada are charities. So if I went to the University of Toronto Law School. The exorbitant tuition that I paid was being paid to a charity. Right? This tells you a few things. Firstly, charities can charge for their services. Now, that's not necessarily a good thing. I didn't have fun paying that tuition, but you can do it, right? It can be part of your revenue model. So that's an important thing to note. So advancement of education doesn't just include universities, colleges, museums, horticultural gardens can be included, zoos are included under this head. Art appreciation societies are included under this category. These categories have developed over 422 years, right? So many things have been fallen under these categories over the years. Advancement of religion. So the most common one is something like a church or a mosque or synagogue, something like that. You can have organizations that do religion promoting things that aren't necessarily places of worship. So for religious publication societies, so they publish books with the idea of promoting the religion, and so on and so forth. Now, religious organizations that engage in social services often may come under more than one head, more than one category. You may fall under religion and also relief of poverty, or you may fall under religion and other purposes beneficial to the community. So then we come to this fourth category, other purposes beneficial to the community. And you may say, well, that's it, that's the one, that's a huge, I'll just fall under that. So there's a bit of a caveat here. It's other purposes beneficial to the community in a way the law regards as charitable. So this comes to be a kind of catch-all category for what the courts have found charitable over the years. There are many sort of recognizable categories that have become very normal now. Animal welfare organizations, for example, shelters fall under this category. Environmental protection organizations like conservation authorities fall under this category. Others include, I'm trying to think of some of the fun ones. I'll give you some particularly outdated examples. I think in the 1920s there was a case, an organization whose purpose was to promote housewifery. Excellence in being a housewife, right? It fell under this category. So it's a broad category if you know how to make the case, right? That you're charitable based on citing past cases and so on and so forth. Then you can be quite creative in fitting into this fourth category. Okay, so registered charities. Why bother? Why go to the trouble of applying to the Canada Revenue Agency, getting the status, so on and so forth? Well, probably the two biggest reasons organizations do it is, number one, to be able to issue tax receipts. Tax receipts give the donor a tax credit on their when they file their taxes, so it reduces their taxes. Tax receipts, some people say, I'm only going to give to you if you can give me a tax receipt. So if those donors are particularly important to you, then it would be important to be a registered charity. Others, it's not so important. What the literature says, so this has been studied by economists around the world, generally speaking, the bigger the donor is, the more they care about the tax receipt. So if your organization is mainly driven by a lot of smaller donors, it's probably less important to be able to issue a tax receipt. But if you're an organization that is really counting on landing a few big donors, that ability to issue a tax receipt is likely to be important. So that's something to be aware of. But it's also a conversation for you to have with your prospective donors, right? The other big reason that organizations get registered as a charity is that it makes them eligible for other charities to be able to transfer funds to them. It used to be charities could only transfer funds to other charities. And then if they wanted to work with a non-charity, it's not so much that they gave the money to the non-charity, it's that the non-charity worked for them on their behalf. So the non-charity was really doing the work of the charity. Now, there was a lot of pushback against these rules for decades, and recently they've changed. And there's, in fact, probably in the next few weeks, the Canada Revenue Agency is going to publish a guide to what are called qualified disbursements. So keep your eye out for this. People, certainly at CLEO, well, the Ontario Nonprofit Network at least is going to publish explainers about these new rules and so on. It allows charities to grant directly to non-charities as long as they follow certain rules. Not all funders are on board, and it's going to take some time to adjust practices, and some funders may choose to never expand to non-charities. That's their prerogative, it's their money. So think about who are your funders, who do you really want to be eligible to receive funds from? I also mentioned that registered charities have more flexibility in terms of how they can raise money. So nonprofits have to follow this idea of we need to break even, or if we're getting a surplus, we need to be able to justify it by a reserves policy. Charities do not have that upper limit. Charities can earn money hand over fist, as long as it's either A, fees that they're charging for their charitable programming. So for example, a theater could be charitable and it could charge a ticket price. B, what's called a related business. And a related business are things like, in the hospital, there's a cafeteria. That cafeteria is related to the goings-on of the hospital. It supports the work of the hospital. Or you're selling a t-shirt or a band that has your logo on it. So that's related because it promotes your charity and so on. There are a few other examples of this. You can read a guide with all the great bunch of detail, all of this online on the CLEO website. So, number one, charging for charitable services. Number two, related business. Number three, charities can hold investments as long as they are passively holding those investments. So I'll tell you, one cutting edge area of charity law is real estate development. Because, I'm sure as everybody knows, we've got a housing crisis, right? We've got lots of problems when it comes to real estate. So many charities want to get involved in different ways, developing housing, and leveraging their buildings if they have buildings, and so on. The problem that they run into is that real estate development is not a charitable purpose in and of itself. So how can they, as a charity, leverage their real estate assets, create more housing, do more? Very often, the strategies that are used by lawyers use multiple corporations. So you'll have one charity, one nonprofit, one for-profit. And the charity will, let's say, own the nonprofit. They'll have shares in the nonprofit. Sorry, shares in the for-profit. And then the for-profit will do the development. And the charity will passively hold the shares in that for-profit. Why do I go into such detail? Because I think this real estate example is a great example. If you have these kind of big ambitions, you can do it even as a charity. right? But you need to be creative, and you can mix different structures and so on. If you're a small organization, it's a massive headache, and you probably don't want to get into multi-corporate entities so fast. But if you're a mid to large size entity and you're wondering about these types of structures, it's possible. What I'll note about charities is that they are subject to far more paperwork and oversight by the Canada Revenue Agency. So if you are going to become a charity, I always say this, be prepared to follow the rules of being a charity, right? It's easy to see the benefits without having the proper structures in place to actually follow those rules. And those benefits can very quickly become detriments if you haven't been following the rules. And then it gets into the press, or somebody complains about you to the CRA, and then the CRA is auditing you, and that's taking forever. Even if they don't find anything, which they'll probably find something. They always find something, right? Even if they don't find anything, the time it takes to go through that audit, right? Better to have all your ducks in a row. So if you're going to become a charity, be prepared to be a charity. Okay. So next I'm going to talk about membership models. Membership, as I've said, is probably the most important decision you will make for your governance structure, regardless of what form you take. If you're unincorporated or if you're incorporated, if you are a nonprofit or you're a charity, it doesn't matter. Membership matters always. The members are the people who the nonprofit, the organization, ultimately answers to. These are the people who have the ability to elect and remove the board. Their approval is required for major decisions like changes to bylaws, changes to purposes, sales of assets, mergers, etc. Okay? Your members are super, super important. If you take nothing else away from the session, please take that away. So who your members are really matters. So what are some different examples? One thing I'll highlight is that there's total flexibility pretty much in who you make your members. So come up with something that works for you. But here are just a few common structures and some of their pros and cons. Okay. I have an extended PowerPoint where I go a slide for each one. I'll just give you a breakdown of each one. Open membership. Open membership is where you say in your bylaws or your constitution, anybody who supports our nonprofit is a member. Okay, well that's great, right? And it may reflect your values of openness and so on. The pro is that if you're more open in your governance, that may be a source of volunteers, maybe a source of donors, maybe a source of future employees, future board members, etc. It can be a way to, as I mentioned, reflect your values and so on. Some of the cons are, number one, if you incorporate, you're expected to keep a list of your members. So the easier it is to become a member, and especially if you say anybody who supports our nonprofit, well, do they have to tell you if they support your nonprofit? Well, we didn't say it in our bylaws, right? So they're all members automatically if they support you, even if they don't tell you. You're expected to keep a list of your members. So that's hard to do if you have very open membership. Some organizations, for example, say anybody who lives in the area is a member of our nonprofit. It's common for residents associations. It's unlikely, I have yet to meet a residents association who actually have a list of all the residents. So it can lead to administrative problems. A second problem that it can lead to, and this is not necessarily a problem, it can also be a good thing, is if you have very open membership, people can disagree. They can have a very different vision for the organization than you. And as I mentioned, members have rights. They have decision-making power. And if they end up having the majority, they can take the organization in the direction that they think is best, which you may not agree with, right? So if you're going to have open membership, be prepared to manage the different views that you are inviting in to your organization. Thirdly, from an administrative perspective, it can be more difficult to organize members' meetings when you have a lot of them. For example, for anyone who has ever been at a student union meeting, you know they're an absolute nightmare. It's literally hundreds of people, thousands, they're all screaming at each other. You need to find a room big enough. It's a mess. My heart goes out to them. But it's a function of their commitment to an open membership, that all the students in the school should be members. And that's a very important value. That's like democracy is often not pretty. And that's true on a small scale within an organization as it's true more broadly. So that's open membership. Semi-open membership is where you say anybody is a member, provided they meet such and such criteria. So for example, anyone is a member provided they pay a $10 fee. Or anyone is a member provided they submit a membership application and they're approved by the board. There are many, many ways that you can build requirements in to membership to protect your organization. You can say the members have to abide by a code of conduct. If you don't abide by the code of conduct, you stop being a member. It's not that we kicked you out. You no longer met the requirements of being a member. Same thing with a fee, it can be a source of revenue. So the requirements can be very important in defining the scope of your community. So those are some of the advantages. Some of the disadvantages of semi-open membership are similar to open membership, and that it can still be a wide range of people. There are some court cases with organizations that fell in this category. So they had a list of things people had to meet. You had to pay a fee, you had to do it by such and such a date. And then somebody applied, a whole group of people applied, and the board said, we don't want these people in our organization. The trouble was, they didn't list the reasons that they wanted to exclude those people. They wanted to exclude those people because those people had a different vision for the organization. But they didn't say that in their bylaws. They said if you pay a fee, you submit it by such and such date, you can be a member. And the court said, look, as a board, you're entitled to decide who isn't a member, but you have to follow the criteria you set out in your own governing documents. So once you set out those criteria, you need to apply them in a fair and consistent way. So be thoughtful about what those criteria are. The third type of membership is sometimes referred to as a self-perpetuating board. This is a structure where the members and the directors are the same people. Some of the advantages of this structure is that it limits the ability for people from the outside to come in and change the direction of the organization. It's administratively easier to hold meetings. Some of the downsides is that it can lead to an insular organization, an organization that ceases to be accountable or transparent to people on the outside. It can become a kind of insiders club that people feel excluded from. It can also lead to governance falling on increasingly fewer shoulders who perhaps aren't able to sustain it. What happens if they leave tomorrow? You don't have that same pipeline of volunteers unless you make an active effort to include people in your governance in ways that are different than membership. Self-perpetuating boards may also be viewed a bit suspiciously. And this is a great point where I'll remind you that the law isn't everything, right? You can have a perfectly legal structure, and this happened, for example, in the We Charities scandal, where they had a structure, and from what I saw, I'm not opining, I didn't read all the documents, but much of what was described in the press was perfectly legal. In fact, lots of organizations have structures like that. But when you put it on a news article, right, it looks suspicious. It looks like, oh, why did they do that? Doesn't sound trustworthy and so on. So be ready, whatever governance choices you make, if you're planning to be out in the public and you think, oh, we may one day be controversial in some way or another, be ready to be able to explain to people why you made the governance choices you did, right? And understand that people have misperceptions or feelings about different governance structures. Probably once or twice a month, I get questions from the public from people who say an organization, their board and members are the same is not legal. Some people find it suspicious. With that being said, it's quite a common structure. I estimate, based on a study we recently concluded, that anywhere between 20 and 40% of organizations in Ontario have a structure, like a self-perpetuating board. And it's increased over time as the sectors become more professionalized. There are pros and there are cons. Interestingly, that same study found, this is a sneak peek because we're releasing it in October, that same study found that organizations with self-perpetuating boards were 3 times less likely than other organizations to have more volunteers than board members. Meaning chances are the board were the main volunteers. Okay, a single member structure. So you don't need more than one member, actually. This is most relevant to startup organizations like social enterprises, where there's one particular individual who starts it, and they want to control it, and they don't want anybody to take it away from them. And they can do that. In a single member nonprofit, it's very hard for anybody else to dispossess that individual of the organization, of the control of the organization. So that member would have the ability to elect the directors. You still need a board of at least 3 in Ontario. Federally, you could have a board of less than 3, as long as you're not receiving more than $10,000 in public funding. But in Ontario, you can have a board of fewer than 3. They'll query if you can't find 3 people to sit on your board, how sustainable is the organization? But you can do it. You have one, in this structure, you have one member who elects and replaces the board, has final say on all the major decisions, like changes to purposes, names, etc. One other thing to note, if you are thinking or you're already involved in a multi-organizational structure, let's say, for example, there's a hospital and a foundation, or there's a charity and there's a development organization or something, one way to create a relationship of control between one organization and the other is to make this organization the sole member of this organization. That's how you affect control. So in the business world, we talk about parent companies and subsidiaries. So with nonprofits, you can also have parent companies and subsidiaries. So the pro, very easy to hold members meetings. You can do it in your bedroom, right? I mean, I suppose you could do it in your bedroom with more people too, but it's much easier, especially if you have a small bedroom, you only need one person. It is, as I mentioned, no one can, it's very hard to take away control. That's usually the main reason people go down the structure. The con is if you looked insular and kind of suspicious with a self-perpetuating board, you're definitely going to look insular and kind of suspicious with a single member organization. And additionally, especially if you're just starting out and you don't want to go to the trouble of recruiting people, your inability to recruit people is a red flag. And so you may want to think about how sustainable is this organization really if I don't have other people involved. It shouldn't really all just depend on me. Okay, and then next we have hybrid membership structures. So it's possible to have more than one type of membership. You could have some members who are voting members, some members who are non-voting members. Non-voting members still have lots of rights. They have rights to access documents, for example. They have rights to take an organization to court in certain circumstances, but they don't have the right to do things like elect the board or vote on major decisions and so on and so forth. So there are ways to include different types of stakeholders at different levels and in different ways. So the example I like to give is there is no age requirement for who can be a member. You don't need to be 18. So in theory, you could have a whole class of membership just for babies. And then you could have a membership meeting, and the babies, you could bring the babies, they could vote. You could have some cute way to get them to vote, it would be wonderful. Right? Probably you'd get more people at the membership meeting, right, if the babies were there. So you can do that legally. I don't think anyone's ever tried. I'd be fascinated if it was ever tested in court. But my reading is you can do that. And you can quote me on that. But the main point here is that you can have multiple classes of members and engage different types of stakeholders. So for example, let's say you're a mental health organization. So you might want to engage users of your service in one way. You might want to engage community partners in another way, because organizations can be members of a nonprofit. You may want to engage staff in another way. Similarly, perhaps if you're a settlement organization, you may engage newcomers in one way, families in one way, individuals in another way. You may engage, if you're an ethnic community, you may engage individuals who are members of that community in one way, individuals who are not members of that community but want to be affiliated in some way in another way, so the list goes on and on and on. You can mix and match however you like. The advantage is precisely this inclusion. You can benefit from much more participation. The disadvantage is it's more complicated, and people very often don't understand their rights if they're members. Unless an organization does a good job explaining what their rights are as members, they won't understand when they're signing up. And as a result, they won't necessarily know that the organization depends on them to do things like come to members' meetings and so on. So if you have the structure, be clear on what the rights are and communicate that clearly and so on and so forth. And then finally, there are representative membership structures. This is most common, I think, in either religious or geography-based organizations. This happens where you have the members of the organization. Those members are in fact elected by others. So you have a regional organization, let's say there's region north, region south, region west, and region east. So the organization only has 4 members, 1 member from each region. But how are those members, how does someone actually become a member? Every person who's affiliated with the group in those regions gets to vote on that member. So they're not voting on the board, they're voting on members. And then those members get together and do things like have a members meeting, vote on the board, etc. So the advantage of this is you can include large populations and not have to deal with the pain of having a list of all of them and having to send all of them notice and having to get all of them in a meeting and so on. You can have a subset and that's enough. The disadvantage is you need to actively maintain this system, which can be, administratively difficult. So the last thing that we're going to discuss in this section, and I'll stop for questions, are shared platforms. So this is sometimes referred to as trustee and trusteed organizations. It's where a group, which may or may not be incorporated, works with a pre-existing group, a more established group, and benefits from that pre-existing group, their bank accounts, maybe their staff, their administrative structure, and so on. Maybe the pre-existing group, which is often referred to as a shared platform or a trustee, offers training, offers mentorship, offers some other kinds of services. Very often it's done because some funder wants to fund the work of this grassroots group, but they're not comfortable funding this grassroots group directly because the grassroots group doesn't have a track record, doesn't have those systems in place, isn't necessarily incorporated. So what the funder does is they fund the shared platform, and the shared platform has an agreement with the grassroots group that we're going to look over, we're going to oversee the money, it's going to be in our bank account, we are going to give it out to you in increments of such and so on, and we are going to be accountable to the funder. And funders are more comfortable with this established organization being the one who's accountable. So the relationship of a shared platform to a grassroots group will be different depending on whether that grassroots group is itself unincorporated, incorporated, or a charity. If the organization, if the grassroots group is unincorporated, then from a legal standpoint, it completely becomes absorbed into the shared platform. So this may feel a bit weird because you may still have your own name, you may still have your own people doing your work, but from a legal standpoint, remember I mentioned unincorporated associations don't exist, it's just people. The only existing entity, from a legal standpoint, is the shared platform. So the people become volunteers or members or something, they become integrated into that broader structure. This is really important, especially if you're trying to benefit from the charitable status of the shared platform. Because if you fail to integrate, it's going to cause problems for that shared platform for the CRA. The CRA wants to see that really they're one and the same. If a group is incorporated, then often it will have a contract that is binding between the two, the shared platform and the grassroots group. And the contract will set out things like, well, here are the services we provide, here's the fee we charge, and so on. If the shared platform is receiving charitable funds, so the shared platform has charitable status, but the incorporated grassroots group doesn't, then until recently, the shared platform and the grassroots group would have to have an agreement called a direction and control agreement, which basically set out that the shared platform would have oversight over the use of all those charitable funds. The rules have changed, as I've mentioned, where it's now possible to have a qualified disbursement agreement in place. How different is it from a direction and control agreement remains to be seen. The final guidance is going to be published this month, hopefully. Yes, there's a question.
Benjamin, have you got an example of that you are aware of nonprofits happened already?
Sure. I'm trying to think of specific names. If anyone's interested in shared platforms, you could go to the Ontario, there are a few places you can go for a rich array of examples. Number one, the Ontario Trillium Foundation. They have about 104 shared platform type relationships. Some of those are organizations with incorporated organizations. Many of them are unincorporated. The other classic example is the Makeway Foundation, previously known as the Tides Foundation. They, in many ways, pioneered shared platforms in Canada. So they have examples, and I think some of their trusted organizations are incorporated. So I would go to those two places for examples. Yes?
Is this different from the role of a fiscal agent or having a memorandum of understanding with a nonprofit?
Great question. So this idea of a fiscal agent probably falls most closely into the direction and control idea. Is it the same thing? What I would say is that shared platform agreements are often more encompassing, and sometimes they're just one project, but often they're longer lasting. And there is a capacity building element in many, which doesn't always exist with fiscal agent relationships, which are more transactional in nature. But I would say that fiscal agent relationships are sort of a component part of what might be described as more broadly a shared platform relationship. Thank you for that question. So there are a lot of terms here. And I'll note that many of these terms are not legally defined, so people use them however they like. So you'll see people use them in different ways, unfortunately. Not unfortunately, I mean, they get to be used for different things, but be mindful of that. So the final situation, this is the rarest, where the shared platform and the trustee organization are both registered charities. And when both are registered charities, resources can flow freely. As long as they align in their charitable purposes, it's basically fine. The rules are quite permissive. Okay, that brings us to the end of this section. Are there any questions about anything we've discussed so far or haven't discussed that you'd like to discuss about choosing a structure?
I just have a specific question.
Yep.
While you are building your organization and you choose one specific member, it's easy to change it 3 months, 1 year later, because you know that what you chose is not the right one. It's easy?
Great question. So the question is essentially, how easy is it to change your membership structure once you've put one in place? And there are two things I want to say in answer to this. So the first thing is, you should expect to make changes. Don't think it's a once and done thing, right? As your organization grows and adapts, you should be prepared to make changes on various things, even fundamental things like membership. You may find that a whole group of people is interested in becoming part of your organization that you never thought about even 6 months ago. Now, how easy is it? So changing membership requires changing your articles of incorporation. If you're an unincorporated association, it's very easy. It's like any other kind of vote. But if you're incorporated, it requires changing your articles of incorporation. To do that, you need to first get it approved by the board, then you need to get it approved by the members, who are voting members. You need to pass a 2/3 vote at a meeting, then you need to file it with the government, either the provincial if you're incorporated provincially, or the federal government if you're incorporated federally. There is a fee of about $155 associated with this change. So what I would say is that changing, every few weeks, every few months probably gets expensive over time, and it's probably time-consuming for the members' meetings and so on and so forth, but it's certainly possible.
Thank you.
Other questions about choosing structures? Okay, so then let's shift gears and look more specifically at the nuts and bolts of what you would need to incorporate. We're going to focus this discussion on Ontario's Not-for-Profit Corporations Act, but by and large it's quite similar for incorporating federally. So your nonprofit's name. Your nonprofit needs a name. I mean, it could just be a numbered company, that's possible, but it may look a bit suspicious as you communicate with donors and stuff. So nonprofits have two kinds of names. They have what's called a corporate name, or you may call it the legal name of the nonprofit, and an operating name or a trade name. All nonprofit corporations have the corporate name. Some nonprofits may choose to also have a trade name. They also have an operating name. What's the difference? So the corporate name is the name that you officially register under when you become incorporated. And that is your official legal name. That is the name that should appear on contracts. That is the name that should appear on official legal documents and so on. So we know who these documents actually apply to. Contrast that with the trade name. The trade name is the name you go by. So for example, there's the YMCA and the YWCA, right? But they're commonly referred to as the Y. So that would be an example of an operating name. Community Legal Education Ontario is our corporate name, but we're commonly referred to as CLEO. CLEO is an operating name. So the corporate name you request when you first become incorporated, and if you want to change it, you have to file articles of amendment. You need to change your articles. And you have to go through the same process I just described. The board approves it, members approve, 2/3 membership approval, and you have to submit, and there's a fee associated with it. Trade names are different. Trade names are governed by the Business Names Act, and the Business Names Act applies to nonprofits, even though it's called the Business Names Act. And it's relatively simpler. You just file a form, and you don't necessarily even need membership approval. Now, in order to become incorporated, you first get a nuance report. The online system for federal nonprofits and provincial nonprofits is a bit different, but actually the provincial online system, the Ontario Business Registry, they're planning to make changes to it to actually make it similar to the federal system. In the provincial case, you need to order that report, and then you go into the Ontario Business Registry and you submit the number of the report that you got. The report tells them that there's no other corporation, either a federal corporation or Ontario corporation, that has the same or deceptively similar name. Federally, that's actually built into the online incorporating system. So you can get your nuance report and incorporate it at the same time. So it's much farther along. The thing to note about nuance reports is that they're good for 60 days. So get the nuance report when you're pretty close to being done submitting your papers to incorporate. The final thing I want to note about your nonprofit's name, names are very important, especially for nonprofits. What do you have if not your reputation, right? So name matters a great deal. This corporate name and trade name stuff is different from what's called trademark protection. So when you incorporate with a particular name, you show up on the corporate registry, and that means other people can't incorporate with that name. But it does not mean that they can't use that name. They could use the name for all kinds of things. If you want the legal right to stop other people from using your name, that requires trademark protection. And that is a separate process that you go through with the Canadian Intellectual Property Office. It's not something I know a great deal about. I'm not an intellectual property lawyer. But there are law firms, charity and nonprofit law firms, that also have an intellectual property component, and there are books that you can find in law libraries and in some public libraries, trademark law, intellectual property law for nonprofits and charities if you're interested in this particular question. So in addition to a name, you need some core people. You must have at least one incorporator. This is like a legal term for founder. Your nonprofit also needs, and this incorporator is your nonprofit's first member. They have the power to elect directors and pass bylaws at your nonprofit's first members meeting. So once you become incorporated, you actually have to have that first members meeting. I know many organizations that they file out all their papers and they think they're done. They've done everything they need to do. And they never have that first meeting. It causes a lot of problems. So if you incorporate, have that first meeting and have it within 60 days of incorporating. And we'll see in a few slides what you do at that meeting. So you have to have at least one incorporator. In Ontario, you need at least 3 directors. As I mentioned, federally you can have fewer than 3, unless you're planning on receiving more than $10,000 in public donations or assistance, or grants or financial assistance from the government. Now, this is just a minimum. Again, the law and best practices are 2 very different things. I will say the average size of a board in a nonprofit board in North America is between 9 and 12. Just because it's average doesn't mean it's the right fit for you, but it gives you an idea of where most organizations fall. I once did a survey in one of these sessions, not scientific, but almost everybody, for whatever reason, had 7 directors. So I'll ask, does anyone here with a board have 7 directors? Okay, see, no 2 groups are the same. Okay, so your directors. Who can be a director? So they need to be 18 years or older. So your members can be anybody as far as age goes, but your directors have to be at least 18. They cannot be bankrupt or to have been found by a court to be legally incompetent. This is not the same thing as being incompetent. Many directors I've been an incompetent director before, but that's different from a court saying this person cannot manage property. They do not have to be Canadian residents. You can have directors who live abroad, or they might live here and not be citizens. That's fine. They must consent in writing to fulfill their duties as directors. So they need to be willing to sign a paper. If they're not willing to sign a paper, that is a red flag. Your nonprofit's address. Many organizations, especially when they start out, don't have offices yet. That's pretty normal. So what do? So Ontario law says you have to provide an address in Ontario. Federally, you can provide an address anywhere in Canada. The address will be publicly searchable. Unless your articles or bylaws or board resolution says otherwise, the law considers this address to be the place where you are going to keep important records that will need to be accessible to your members if they ask. Board and members meetings will by default take place at this address, unless you say otherwise, and you can. You can have meetings elsewhere. And important documents will be sent by the government to this address. Now, if you don't have a physical location yet, what do? So here are a few examples of what nonprofits do. Number 1, you give a member of the board's address. Now, this is easy to do, but they may not want it to be publicly searchable. And if your directors are changing often, it can be annoying to change your address that frequently. A second option is if you're working with a lawyer or an accountant, you can ask them if their office offers the service of providing their address for the public registry. Many offices do. Thirdly, some municipalities, some community centers, offer the service of a mailbox to local nonprofits. I don't know what the situation here is in Chatham-Kent, but it's a conversation that you can have with your municipality if they would offer it. Number 4, in some places there are shared office spaces. In Toronto, we have a Centre for Social Innovation. There's 10C in Guelph, for example. So there are examples throughout the province. I know there are a few in Ottawa and so on. Now, sorry, before I go on to purposes, I sometimes get asked, does a P.O. box count? The answer is no. It used to be acceptable, but it's no longer acceptable. You have to have a physical address. I am well aware of the fact that this disproportionately affects smaller organizations, rural organizations, remote organizations who don't have reliable mail service. Both CLEO and the Ontario Nonprofit Network have repeatedly brought this problem up to the Ministry of Public and Business Service Delivery. If this is of concern to you, I invite you to also share your concerns with the ministry. That's the ministry responsible for Ontario Not-for-Profit Corporations Act. So your nonprofit's purposes. Besides your membership, your purposes are probably the core question of your organization. What do you exist to do? A nonprofit can have any legal purpose other than making a profit. Anything goes, basically, as long as it's not illegal. It's a fun activity to look through the list. There's one list online from 2013 of all the nonprofits, and you will see wild things. I'll give you just a few examples of some of my favorite types of nonprofits that I found when I read through this list. In Ontario, there are UFO societies, there are cults, there are organizations dedicated to cryptozoology. It's wonderful. It's the beauty of civil society that we have such a diverse group of different types of organizations pursuing all kinds of different ends. So you can have whatever purpose you can dream up, as long as it's not illegal and non-profit. And if you have a profit purpose, you can just be a business corporation. Now, I mentioned that both nonprofits and charities can do things to earn revenue. So, can you engage in commercial activities? Absolutely you can. But if you do, you just need to say when you incorporate, and the system will ask you. You just tick off a box saying, essentially, our commercial activities are only in support of our nonprofit activities. We're going to take the revenue we earn and we're going to put it back into our purposes.
Excuse me.
Yes?
Can you give an example of a commercial purpose
Sure.
for a nonprofit?
So, selling t-shirts. You might sell t-shirts with the name of your nonprofit on it. You may host events. You may offer translation services. Some nonprofits, that's what they're dedicated to. They offer translation services, and they operate like a business in doing that. But why are they doing it? They're doing it to make justice more accessible, or to make more children's books available in more languages, or whatever. So you can engage in basically any kind of commercial purpose you want almost, as long as it's in support of the nonprofit purpose. Now, I mentioned earlier, if you want to be a charity, you have to have very specific purposes. Your purposes need to exclusively fit within those 4 different categories of charity. And we've already talked about those. So I mentioned once you've filed, and there are 3 ways that you can actually do the filing. You can do it to the Ontario Business Registry. You can do it by mail. You download forms from the Ontario Forms Repository and mail them in. Or you can do it by working with a third-party provider. And the 2 third-party providers are listed on the Ontario Business Registry. Once you've actually done the filing, you then need to have your first meeting. What happens at this first meeting? So after receiving your articles of incorporation, so once you make the filing, the government will send back documents saying, we stamp this, it's approved. And interestingly, federally, if you apply to be a nonprofit federally, there's incorporation as of right, meaning they have to incorporate you unless there's some big red flag. In Ontario, there's no incorporation as of right. They could, in theory, deny anybody, but practically speaking, they accept everybody unless there's something missing or there's something fundamentally wrong in your incorporation. So once you've incorporated, you have to have a first meeting. The first meeting is a board meeting. So whoever you listed as your first directors, they're the first people who have to meet. They have to do the following. Number 1, they have to approve a set of bylaws. If you already had a set of bylaws before you incorporated, and now you're incorporating, you need to approve that set of bylaws again. Because when you incorporate, you're creating a whole new legal entity. So it's like it's starting from scratch, legally speaking. You need to call, the board needs to call a members meeting. So especially if your directors and your members are the same people, this can seem artificial, but you still need to have board meetings and members meetings. And you need to keep those 2 separate. You need to keep the records separate. There need to be separate minutes, separate agendas. There are different procedures that apply to voting on things at board meetings versus members meetings. Just because they're the same people does not mean the same rules apply. So the board needs to meet and call a members meeting. And they can call that meeting and they could call it for right after the board meeting. And it could be the same people and they could just meet again. That's fine, but they have to do it. You need to make banking and financial arrangements. So it would be at this point that the corporation would open up its bank account. That's the corporate bank account. You may, as an unincorporated group, already have a bank account, but that bank account will be tied to specific individuals. It won't belong to the corporation. The corporation is a new person. It needs its own bank account, not just a bank account of individuals. Appoint officers. So the Ontario Not-for-Profit Corporations Act says that nonprofits need to have a chair. I don't believe this is a requirement federally, but I can't remember. The chair needs to be a director as well. So one of your board members has to agree to serve as chair. What's the job description of chair? There's no job description, it's whatever you decide. So that's up to you. You can create other officer positions if you like secretary, president, vice president, that's all up to you. But what the Ontario Not-for-Profit Corporations Act says is you need a chair. Now, once the members, yes?
Is there an online tool that can manage all the meetings and even the
Great question. So, CLEO, we have a bylaw builder that will help you create bylaws. So you can just answer a series of questions and it spits out bylaws. So that part, yes, we've developed a tool for. The meetings part, there are tools out there. You need to be careful because they're primarily American. They're primarily not for nonprofits. Even the ones there are a few for nonprofits, but they're American. So they are not tailored to Ontario law specifically. Ontario law and the law of many states in the US is similar. I'm not entitled to practice in those other states, but I've studied them somewhat. So they're somewhat similar, but you do need to be careful. There are some differences. So the answer is kind of yes or no. You can develop a basic system, but it won't be exactly right for Ontario.
It seems too much paperwork.
Sorry?
It seems too much paperwork. Too much
Yeah.
law to say.
Yeah, exactly. And so when we go back to the pros and cons of incorporating, definitely one of the cons is the paperwork. You need to be willing to do all this. And this is just the first meeting. So if this is already in over your head, it may mean that the organization is not at a stage yet where it's ready to become incorporated. And I'll tell you, I don't know, semi-regularly, once every few months, get an inquiry from some member of the public who says, we're a small organization, we incorporated decades ago because someone told us we had to. We haven't kept any of the paperwork up. We've never had meetings. How do we just close down? And closing down is its own set of paperwork, and it's a bit much. So, yeah, organizations should really do a readiness assessment for themselves. Is the incorporation really right for it? But yeah, it's a lot. There are some tools to help manage it. They just don't manage everything. Once the board is met, the members need to meet. They need to vote to approve those bylaws that the board has voted on. They can accept them, they can reject them, they can change them. That's the members' prerogatives. The members then elect a new board. So that first board only serves until that first members' meeting. Once the first members' meeting has happened, they then elect a new board. It could be the same people or it could be different people, according to whatever the terms are in the bylaws. Now I'll just tell you, under Ontario's Not-for-Profit Corporations Act, and I believe it's the same term limit federally, the term limit is 4 years. So a director can't serve a term of more than 4 years. However, a director can serve as many terms as they like. It just means there needs to be an election at least every 4 years. You can say in your bylaws a shorter term. You can say no, it has to be an election every year or an election every 2 years. That's fine. You can say nothing. If you say nothing in your bylaws, then there's an election at every annual members meeting. The first members meeting also, I see your question, the first members meeting also has to appoint an auditor. Nonprofit corporations in Ontario, by default, need to get an audit each and every year. However, many organizations have the ability to waive an audit. To learn more about the financial requirements, you can visit our website, nonprofitlaw.cleo.on.ca, and don't worry, you'll get that link after today's session, and you'll see we have a page setting out the requirements for who has to get an audit when. This is one of the major differences between Ontario and the federal statute. There are different annual revenue thresholds about when you have to get an audit, when you can get a review engagement, and so on. Fortunately, the federal government actually has a good website in this area where that has a lot of detail about what are the financial review requirements and so on. So if you go to Corporations Canada and you look up nonprofit corporations, you'll find details about that.
should your auditor be from within your group or from outside your group?
So the auditor would be an independent chartered professional accountant. So they need to be independent. Your question?
So, can the director be paid?
Great question. This is often a really crucial question for organizations when they're first starting out. The answer is, for regular nonprofits, yes, directors can be paid. They can even be paid for their work as directors. They could be employees, they could be contractors, they can supply the nonprofit. Now, directors are obligated to put the interests of the nonprofit first. So that means that whatever the pay is, they cannot be involved in the vote because there would be a conflict of interest. So that 100% applies. But it can lead to limitations of that person sitting on the board if they are constantly decisions coming up that involve their personal interests. So that's one thing to know. The second thing is that if an organization qualifies as what's called a public benefit corporation, which means either they're a charity or last year, more than $10,000 of their funding came from public sources, such as grants or financial assistance from government, or gifts or donations from members of the public. That organization, only up to 1/3 of its board can be employees. Now, if an organization wants to be a charity, the rules are far more restrictive. For a charity, directors can never be paid for their work as directors, period. However, a charity can, in limited circumstances, have an employee on the board. One thing I want to note, reminding everybody of the disclaimer I said at the beginning, there's a difference between the law and best practices. There's a difference between the law and your funder's expectations. Many funders will view directors being paid as a red flag. It is the kind of thing that when it shows up in the court of public opinion, if there's a news article about it, it never looks good. So it's something to be mindful of. How is it going to be perceived? Who are we going to need to communicate this to, etc. But it's not prohibited, except for charities in most cases. The last thing I'll note is that if your organization does not have a set of bylaws within 60 days of it incorporating, then the default bylaws under ANCA automatically kick in. This is another difference between provincially and federally. Federally, there are no default bylaws. So there are a bunch of rules that automatically kick in, but there's no one document that you can clearly point to and say, these are our rules. ANCA has a default set of bylaws that you can Google, and that's what applies if you haven't passed your own set of bylaws. There are pros and cons to that. Okay, that brings me to the end of this section. Are there any questions about applying for incorporation? Okay. The next thing we're going to talk about is applying for charitable status. Now, in theory, an organization can apply for charitable status whether or not it's incorporated. It used to be far more common for unincorporated groups to apply for charitable status. Now, the vast majority of organizations that apply for charitable status are either corporations or they're trusts. It's outside of the scope of today, but if you want to talk to a lawyer about setting up your organization as a trust, it is much simpler, so there's far less paperwork than setting up a corporation, but it doesn't protect you from liability in the same way. And there are more restrictions in terms of what it can do versus a corporation, which has all the legal powers of a regular person. When an organization is applying for charitable status, if it's planning on becoming incorporated, CRA, the Canada Revenue Agency, wants to see that you're already incorporated. They do not want to receive the charitable application at the same time that you are applying to be incorporated. You don't do them at the same time. First you incorporate, then you apply for charitable status. What this means is that you should have it, if you're planning on applying for charitable status, you need to have that in mind from the beginning. And you need to write your governing documents, you need to design your governance structure with charity law in mind, so that you don't have to do everything twice, where you incorporate and then you change everything over to make it compatible with charity law. So we're going to talk about 5 things here. An application checklist to just talk about what's the kind of information that you can expect will be required as part of the application. I'm going to talk about the actual process, give you a bit of a sense of timeline, acceptance, rejections, what happens. 10 common reasons for rejection. So this is the low-hanging fruit. This is the stuff that you should be able to avoid. Working with a lawyer, I'll give you some tips on that. And then finally, where to learn more. So application checklist. So you may need to provide any or all of the following documents to the Canada Revenue Agency. Number one, your incorporated documents. So they're going to ask to see your articles and your bylaws. They want to see that your purposes are exclusively charitable, and there's nothing in your bylaws that contradicts the exclusively charitable character of your purposes. They are going to want a bunch of detail about your activities. To be a charity, it's not just your governing documents that need to be exclusively charitable, it's all your activities. They want lots and lots of detail. And the more detail you provide, it's kind of there's a pro and con. So the pro is the more detail you provide, the less back and forth you may have, because they're going to have less to ask you for if you just provide it all up front. The con is, if you've got a lot of materials, particularly if you've been operating already for a long time as an unincorporated group, and you have a lot of materials, and what those materials say show a mix of charitable and non-charitable things, you better be ready for the questions about the non-charitable stuff. Now, they do their own searches. They do web searches, they do whatever searches are available to them. So hiding things because you don't want them maybe to see it, may come back to bite you, because they may find it anyway and ask you, A, what's going on here, and B, why didn't you share this with us? And then you're going to have to explain it anyway. So very often it's a good idea to get ahead of the game. Every case is different, and of course, consult a lawyer as appropriate if you're in a complicated situation. But my personal approach is to be transparent and forthcoming as much as possible, and just be ready to explain everything about the organization and how, if things have been non-charitable in the past, why things have changed and how things are going to be charitable going forward. And that nips a lot of things in the bud, that heads off a lot of questions. There are different approaches though, so I'm not advising a one-size-fits-all for everybody. They're going to ask about income-earning activities. So how are you planning to sustain yourself financially? Are you planning on having fundraising events? Are you planning on charging membership fees? Are you planning on engaging in businesses? They want to know, because as I mentioned earlier, there are some things that charities can do to raise money, to engage in business. There's some things they can't. I didn't even mention fundraising earlier, but charities can, of course, engage in lots and lots of different kinds of fundraising. They will want financial information, including any existing financial statements if they exist, and or proposed budgets. What they do with this, I think, is a much more of a practical assessment. Is too much going to admin? Why is so much going to admin? Etc. There's no particular budget composition that a charity is required or not allowed to have. So this is more for their holistic picture of the organization. That's my personal understanding. And then finally, any partnership agreements. If you're an organization, let's say you're an unincorporated chapter of a broader group, so you already have this existing relationship with the umbrella organization. CRA wants to know that. What they're concerned about is that a charity is going to have a relationship with a non-charity that's going to take the charitable property and be used to benefit the non-charitable partner. So if you do have these partnership relationships, then CRA wants to know about them. And if they're with non-charitable organizations, you need to be prepared to explain how you aren't going to inappropriately benefit them. How this relationship is ultimately for the best. It's going to further the charitable purposes. Okay, so the application review process. So the first thing they do, and you can submit it online. It's much easier to submit things online. They switched over to an online system a few years ago, and they've been pushing it ever since. They want people to use it. However, it is your legal right to use another approach if you want to or if you need to. So you can request those forms from the CRA if you need a paper version. But the first thing that they are going to check is the completeness of your application. Did you include all these documents? Did you fill in all the boxes? Did you include all the attachments, etc.? If the answer is no, if it's incomplete, rejected, big waste of time, right, for everybody involved. So make sure things are complete, if nothing else. Now, when it comes to assessment on the merits, just to give you context, I don't know, I think there were I think the number was about 1,500 applications last year, something like that. I may have it on the next slide, I can't remember. But there are over 1,000 applications for sure, maybe closer to 2,000. 80% of them are accepted. So it's not impossible. I don't know what percentage of those worked with lawyers, but it's not impossible whether or not you're working with a lawyer. There are certain complex cases where I'd say you're unlikely to be able to make the case unless you know how to make it legally. But in many cases, if you are following a well-trodden path, if you're an organization that is similar to many other kinds of organizations that you see at charitable status, it's quite likely that you can qualify if there aren't any specific disqualifying issues. So it's not impossible. With that being said, there can be greater or lesser back and forth, because mostly what happens is when people submit, three things can happen. Either they accept you right off the bat, they reject you right off the bat, or they say we need more information. Very few people, unless they're very well advised and they're simple organizations, get accepted right off the bat. A minority of organizations get rejected right off the bat. The vast majority of organizations, there's a bit of back and forth. Right, so you need to be prepared for more questions, and I'll just tell you right now, the letter they send is long, and it's dense, and it's because it's cookie cutter. They have standard things they tell everybody, and they just copy and paste those things in. So the fact that it's long and the fact that it's dense is not a reflection of you, okay? It doesn't mean anything's wrong. You didn't do anything wrong. It's just a reflection of how the system operates because they receive so many applications. So acceptance, rejections, or need more information. So if they tell you that they need more information from you, you have 60 days to reply. So make sure they have the right address on file, right? Make sure you're checking your MyCRA account and so on, right? You don't want to find out on day 50 that you have 60 days to respond. There's a good joke about a guy sees a doctor. The doctor says to him, I've got bad news and worse news. The guy says, what's the bad news? He says, the bad news is, you've got cancer, you've got about a year to live. That's the bad news. What's the worst news? And the worst news is we were set to have an appointment about a year ago. So you don't want to run into that situation with responding to the CRA. It's going to take time probably internally to work out the answers to all their questions. So book time accordingly, right? Book meeting time, it's going to show up. Your board needs to be prepared to meet, right, when you undertake this process. If you fail to respond, the CRA considers the application abandoned. And that means you're denied. If you do respond, they'll respond with either an accepting or a rejection. If they reject you, it's not necessarily over for you. You can appeal. You can appeal within the CRA to the appeals division, and you have 90 days to do that. You need to explain why you think the CRA is wrong. And this will be most relevant if you're doing something cutting edge. If you have a new, innovative purpose that you don't think has been recognized as charitable in the past, that is where these appeals are very useful, because the policy positions of the CRA are always changing as things are coming in, policies are shifting, the law is shifting, things are happening in other jurisdictions in the world. So think about it. Certainly an appeal is a moment where you may want to consider getting legal advice, if only to navigate the process. A tax lawyer, a charity lawyer who's familiar with the appeals process. Now, based on your appeal, the appeals division can either accept or reject it, and then your next appeal is to the Federal Court of Appeal. It may be simpler to just abandon your application and just start from scratch. Just take what you learned from everything the CRA said, and just start again. That's much faster than trying to go through a court process, which can take years. And it's very expensive, and it's public. So how's that going to impact the reputation of your organization? Maybe good. Court cases can be great fundraising drivers, right? But it can also be bad. So every organization needs to decide for itself. The typical timeline that I heard for many years, and that I was telling people for many years, was 9 to 12 months. I'm happy to report that recently I've had a number of experiences that is faster. It's happening in 3, 4, 5 months. Great. Again, it varies depending on the complexity of your case. They have a triage system where simple cases are dealt with faster, more complex cases can take longer. So be aware of that. So here are 10 common reasons organizations are rejected. Number one, the most obvious, is the purposes just aren't charitable, or they're not exclusively charitable. The best way to avoid this problem is by doing research ahead of time. Unless you're willing to essentially make it a wager of, okay, we'll just submit our best guess at what's charitable and we'll let the CRA decide, right? Then you can do the reading ahead of time. You can speak with experts ahead of time. There's a fair bit written online. The CRA itself, its website, has so many guides you can read about many charitable purposes that I'm sure many of you will fit under one or another. And as long as you fit within that guide, you adopt the language, you know how to use it, you understand the scope, then that will considerably reduce the risk of you being rejected for the purposes of not being charitable. Purposes are broad and or vague. So the CRA has a whole guide just on how to write the purposes of your organization, the way they want to see it. I won't get into the details, but you can access this guide for free online. And what they want to see is that the purposes are written in a way where it's clear that the only things that you could do to further these purposes would be charitable things. Very often, organizations have purposes, especially when they're starting out. People, they're not used to writing purposes of organizations. People say what sounds good. They say what makes sense to their community. It may be things like, we want to promote well-being. Well, that's great. What does that mean legally? Right? Promoting well-being could be handing out teddy bears to children, or it could be dealing LSD, right? According to some people. Dealing LSD, not charitable. So, in case anyone was wondering, it came with that question specifically. The CRA wants to be able to read the purpose and be able to see, okay, I see the box, and what fits in is charitable and charitable only. Another problem is the purposes don't reflect the activity. So some organizations say, okay, we talked to a lawyer, we wrote everything down perfectly, and then they start describing what they're actually planning on doing, which has nothing to do with what it says in their documents. The documents are just because the lawyer told us we had to. This is what we actually want to do, right? The purposes and the activities, they have to flow from each other. This gets back to what I said at the very beginning. If you're incorporating or you're applying for charitable status for reasons because you think you have to, not because it makes sense for your community, you're going to run into a tension where what counts as charitable does not fit the actual mission of your organization. This can result in mission drift, it can result in a compromise of your values, and that can lead to people falling away from the organization because this isn't what they signed up for, and so on and so forth. A lack of information. CRA wants details. Unstated collateral purposes. So if you write down everything the lawyer told you to write down, if you work with a lawyer, and you write down all the activities and all, it's all very good, but it's pretty obvious from reading it that there's something else going on. There's something behind the scenes. Either there is some kind of political motivation, or there is some kind of, and motivation is the wrong word, it has to be a political purpose, or there's some kind of other unstated purpose. Like really you're doing this to benefit somebody that isn't mentioned in the document, or so on and so forth. This is what auditors are trained in, or the application reviewers are trained in, to look at an organization holistically and say, is there anything that's suspicious, right? So this is another reason that organizations are commonly rejected. They weren't forthcoming about all the reasons that they're really pursuing. Lacks public benefit or delivers improper private benefit. So lacking public benefit means that you may think your organization is great, but the law has not yet recognized the thing you think is great as a public benefit. So for example, as a public benefit that is charitable. So for example, sports organizations are the classic example of organizations that, in fact, courts have recognized as being publicly beneficial, but not in a way that's charitable. So sports organizations do not qualify, generally speaking, as charities unless they are more specifically for, let's say, at-risk youth, or they're people with disabilities, or seniors, or there's some more specific charitable aspect to their work. That's not to say that sports aren't important. Again, courts have recognized them as being publicly beneficial, but not in a way that the law regards as charitable. Improper private benefit means somebody, this is the example of the director is being paid, right? That's an example of an improper private benefit often, or there's some kind of business relationship. So businesses sometimes open up corresponding foundations, or they sometimes open up a charity, and what does the charity do? They basically provide the product of the business at a lower cost or something. Well, if that charity is buying the product from the business, right, and that's all the charitable funds are going to buy the product so that it can provide it, right, that business is getting a benefit. That may be an improper private benefit. Fundraising is the main purpose of the organization. So interestingly, fundraising isn't a charitable purpose. Promoting health is a charitable purpose. Raising money to promote health is not a charitable purpose. So if it seems like all an organization does is raise money, and that's its whole purpose, is just raise money for the sake of raising money, it's actually not charitable from a legal perspective. So you may say, well, what about organizations that spend most of their time just raising money? Right? There are many charitable organizations like this. Hospital foundations, for example. Well, those organizations have written their governing documents in a way that say, our purposes are to promote health. The way we promote health is by donating money to a health promotion organization. They may even say, our purposes aren't even specific to health. Our purposes are to grant to qualified donees, to make grants to charities or whatever. And then in practice, what they do is fundraise. Promotion of culture, multiculturalism, or mutual understanding is not charitable. This is an interesting one to make the list because it shows you how many organizations are applying under this head. Multiculturalism, of course, very important. There are a few court cases that have happened, in, probably the last one was in the 90s, I think, or the early 2000s, but there were a few in the early 20th century that found that multiculturalism or cultural associations, just on their own, if their job is just to promote culture, it's not charitable. There are various reasons that probably have to do with the Anglo-Saxon origins of charity law about why this is the case, what falls into charity, what doesn't. But it is what it is as far as the current law goes. With that being said, organizations that have a cultural aspect often do many things that are charitable and are regarded as charitable. For example, poverty relief, education, literacy, certain kinds of job searches or assisting with jobs can be charitable. Not all, it depends if the person's in poverty or not, and so on. So cultural organizations, there are many cultural organizations that have become registered as charities, but they have to frame their purposes as not just promoting the culture. It's often to promote something else which is charitable. Direction and control is where oh yes?
Sorry, I have a question about that.
Yeah.
How often are these guidelines looked at and so that they can align kind of with today's society and needs? For instance, I'm thinking specifically about reconciliation and things like that. So how often are these looked at and updated?
So it's a great question. So the answer is both constantly and seldom. So they're constantly being looked at in the sense that the CRA is always developing new guidances. They are always looking at revising old guidances. It is a long and cumbersome process that takes years and sometimes decades for many reasons that are not for tonight to get into. The other thing is the traditional way that these things developed was through court cases. And in Canada, we have very few court cases. Because of the way the court system is set up for charity, it's very expensive, it's cumbersome. In other jurisdictions, like in England, New Zealand, and Australia, they have a charities commission, which has a simpler appeal system, so there are cases more often, so the law develops much faster. Here, it's much more cumbersome, but I would say at the individual case review level, the staff of the CRA are very attuned, and they may be willing to look on a case-by-case basis at what is our position on this particular thing, and that position may be able to be more flexible than what they can say in a public guidance which has to apply to everybody. It's much easier to rule on a specific case than it is to issue a guidance that's going to be the binding position of the CRA, more or less binding for everybody. Yes. Now, on the specific question about reconciliation, it's actually interesting because there was a case in the late 70s called, I forget what it's called. I'm rusty on the court cases, unfortunately. This 1979 case, you can find it online. I think it's a Native Radio Association or something. It was a radio organization that was organized to promote the benefit of Indigenous communities by spreading awareness of arts and culture and news for Indigenous communities. And it was found to be charitable. And so there's an independent head of charity, which is promotion of benefit of Indigenous communities. That's a more contemporary term. It uses more outdated terminology, but it's actually quite a wide purpose. And in my view, quite underutilized. And there have been reports about like how much in terms of charitable dollars actually go to Indigenous organizations, which is a whole other issue, which tells you that even if you get registered, it doesn't mean there isn't all kinds of systemic biases within the charitable sector about who gets funding and so on. So it's not just on the CRA, there are other things to consider. But actually there is a lot of room that has not been fully leveraged within the law, even as it currently exists. Just being mindful of time, I'll just give you a few notes on working with a lawyer, because this is a popular topic. So the pros of working with a lawyer is that can be faster because they've done this before, they have templates, etc. There can be less back and forth because they know how to get it all in, all the information the CRA needs the first time. You may otherwise be denied for avoidable reasons, particularly if you're on a kind of cutting edge, kind of charitable purpose, and it can enable innovation. The cons are, it can be expensive. I've heard estimates of $6,000 to $12,000. That's quite normal for a charitable application from somebody who really focuses in this area. And it can be disempowering. It can be harder to really articulate your true vision when there's an expert in the room and the expert is telling you, this is what the CRA needs, this is what the CRA needs. Now, a good lawyer always says, okay, well, I'm just advising, and you are making the decision at the end of the day. But it can be hard to disagree when you're paying so much money for this advice, and then you don't take it at the end of the day. And then not all lawyers know charity law, right? So that's something to be careful about. Ask people about their experience with charity law. What I would really emphasize is that working with a lawyer is not all or nothing. You have an active role to play in deciding things about your governance, as I've said, and learning about charity law, what counts. Because the lawyer, once you get a charitable status, if you do, is likely not going to be able to be there for you all the time. And if they are, it'll be very expensive. So you need to actually understand the rules. You need to understand your own purposes. You need to understand what activities are acceptable and what activities aren't. That's something only you can do for yourself. You can. The great thing is, by learning more, by doing much of the work yourself, by targeting your questions to the lawyer, that also brings down the price. So you get two birds with one stone. On our website, there is a directory of lawyers who work in nonprofit charity law. We don't vet or recommend anybody, but we confirm it makes up part of their services. I have linked at the end of this presentation, and you will get a copy of this PowerPoint, a bunch of key guidances that may be relevant to you. Finally, you can find my email up here and the website, nonprofitlaw.cleo.on.ca. I can answer questions and provide legal information, but not legal advice. I will note that this stage of this project is ending sometime at the end of October. And then I'll be off, as I mentioned earlier. I'm expecting a baby. So you won't be able to get in touch with me after the end of October, at least for a while. So if you do have questions, feel free to submit them by mid-October at the latest. Are there any final questions? All right, thank you so much for your time and attention, and I wish everybody the best of luck in figuring out a structure that works for you and doing your important work for your communities.